Shareholders Agreements. The umpire of shareholders behave badly. My name is Kerri Thomas and I'm a solicitor here at Clarke Hemmerling Lawyers. Does your company need a shareholders agreement? As soon as you have more than one shareholder in a company, there is more than one person that has control of the company. Shareholders, as a group, generally have the best intentions for the success of the company, but with any group of people, different personalities and opinions will often compete and not always align. Once a company is underway, things change over time and shareholders might not always agree on key issues. For example, where the strategic direction of the company is to head, where money is to be directed when upgrading or purchasing new assets, such as vehicles, equipment or property, how the company and products or services should be branded and promoted. Some shareholders might want to grow the company and seek more investors, and other shareholders may want to take a more conservative approach and maintain a smaller operation. Shareholders can wrongly assume that a company constitution has all the protections and dispute resolution processes necessary to protect them if something goes wrong. But in fact, many company constitutions are drafted broadly and don't step out in detail how the company is owned, managed or controlled when there are differences between shareholders. A company constitution will often lack detail on how shareholder disputes should be resolved, don't encompass shareholder protections, or outline the process for shareholders to exit the company. A shareholders agreement helps to protect the company by setting out rules to limit shareholders being involved in activities that compete with the company's primary business. It will also appeal to investors, knowing the business is well structured and respectful of its members. A shareholders agreement can set out the different matters that should be decided by board and those matters that should include shareholder participation. Importantly, a shareholders agreement will record how directors will be appointed or removed. The shareholders agreement will outline the consented conditions in which shareholders may assign, sell or transfer their shares, as well as list their protections for smaller shareholders. It may also provide detail on how and when dividends will be distributed. A shareholders agreement forces shareholders to think about what can go wrong and put contingencies in place if they want to extract themselves or manage a rogue shareholder, not acting in the company's best interest. A shareholders agreement should be set out in clear rules and expectations, as well as provide a process for a aggrieved shareholder to bring an action against another. If a breach of the shareholders agreement is serious, it will provide a mechanism to potentially suspend a shareholder's voting rights or perhaps force a transfer of their shares to other shareholders in certain circumstances. If you think a shareholder agreement is right for your company or you don't currently have one, get in touch with us here at Clarke Hemmerling Lawyers and we can assist you in drafting a tailored shareholders agreement for your business.